16. Now, everyone should have a copy of. Is that correct? Has everyone got a copy of that? There was some discussion on I think it was Friday, Saturday, maybe later. The weekend, Peter Bevan raised a point about the principles of this future discussion be held in public, and I couldn't see any reason why that wasn't upheld. So that's why we're now doing this in public. I do, though, state that Council wishes to maintain its legal privilege in this discussion at this stage. So if we do stray into areas of specific detail, I may stop you at that time. Just give everyone fair warning on that. So I'll hand that over to the Chief Executive.
Thank you, Mr. Chairman. Can I, do you mind if I invite Lara Blomfield, one of our legal counsel, up to the front? Thank you, Lara. She will be also answering questions as we go through. So,
can I just ask a point of order clarification from you, Chair? I'm just trying to get clear in my mind the line that you have drawn. You said, so we're going to get into the detail of the case, then discussion or raise questions about the detail of the case, then that's legally privileged or whatever the phrase you used, and you'll rule that out. So if that's the case, if that's taken, then how are we going to engage effectively on a discussion about this?
Well, let's let the Chief Executive take us
So
through
I just want to be clear about that. So before we get into it, as we're thinking of people presenting stuff, I want to know where I can move and where I can't.
Sure. So when, and perhaps I'll put this in the context of how we normally manage, situations like this with our appeals, and in this case, a referral back to the board. In any RMA process that involves a board of inquiry or an environment court, there's inevitably some horse trading or, more formally negotiations that go on around the details of whatever's under appeal during the process of the actual hearing itself. And staff need the ability, I guess, to be able to know how far they can go in terms of that horse trading. So what we want to do, and hence the reason for this as well, is to establish your principles that will guide us, and particularly our legal counsel, through the Board of Inquiry discussions to ensure that the response that we are currently drafting and that we have to submit by tomorrow is within those principles, and really just to provide us with the boundaries. So that's really where I'm getting to. I think what we're referring to around legally privileged position is the detail of what's being submitted tomorrow, because that has yet to be finalised. We need to ensure that whatever you come up with today, what we draft is consistent with that, and it will be submitted in accordance with the board's timetable. Proposed to do, I've just got, it's only like literally 6-7 slides, and it really just first of all summarises this paper, and then secondly I've put up some principles for discussion, and I'll hand those out as well so that everyone's got them in front of them when we get to them. But I just really, the High Court decision, as you will be well aware, came out just before or not long before Christmas last year, and I'm just spending a couple of slides, and certainly the paper goes into a little bit more detail about some of the key findings of the High Court judge. Council and HBRC were strongly criticised in some quarters for the scope of our comments back on the draft decision, and that was challenged to the High Court. The High Court judge found that we were within scope, and so there was no action taken there. But he did find that in terms of the board itself, the Board of Inquiry, and its final decision, it made a couple of perhaps fundamental errors of law. One of those was around the whether or not Part 2 of the Resource Management Act, which is the purpose and principles, was properly applied. And the second bit was really around that principle of natural justice. So once the board had moved from its draft decision through to its final and had incorporated the deeming provision, whether or not it had given other parties adequate opportunity to feedback, and the judge found that no, they hadn't. So for both those reasons, he has referred those particular matters back to the Board of Inquiry. Did the board properly apply the National Policy Statement for Freshwater Management 2011? The judge decided yes, they did, except for the deeming provision of Rule TT1J. So just to remind you, or to inform you if you're not sure, Rule TT1 is a permitted activity rule that allows for the use of production land within certain areas. Kick in if I'm starting to go wrong anywhere. Condition J, which is the one that's been referred back, not the whole rule, said, or the board said in its final decision, that if a farm property was managing its discharges within the land use capability set out in a particular table, 5.9, etc., then it was deemed not to be contributing to the 0.8 DIN limit. So that was where they said, the deeming. And this is really where the Board of Inquiry itself came under criticism from the High Court judge, who has, I guess, by referring back, has given them the opportunity now to fix this up, obviously both in terms of its legality and also in terms of the process that they used as well. So this is really the crunch of what's gone back to the Board of Inquiry. Another couple of key points, I think. Objective TT1F, now that's actually set out in the wording on the front, on page 3 of the white paper agenda here. This said, the taking and use of water for primary production and the processing of beverages, food and fibre is provided for. And that was appealed by some of the parties to the High Court, but the judge upheld the board's decision to retain this objective, and he held that it did not undermine the primacy of the environmental protection provision. So that's quite significant, that objective stays in there. There were a number of points of appeal on the granting of consents to the Ruataniwha water storage scheme. Those points of appeal were not upheld. The consents for the Ruataniwha water storage scheme remain in place. The time for appeals to the Supreme Court on those that has passed. There are none, so consents are effectively granted. Now, in terms then of what happens next, you will be aware that the Board of Inquiry now has to determine the process. They've never had a referral back from a High Court judge before, so it's all a bit new to them and to everybody. But they issued a minute last Friday and advised that they intend to hold a conference on next Monday, the 2nd of February, here in the War Memorial Centre in Napier, to discuss procedural issues for the High Court's decision. And under discussion that day will be the proposed revisions of Rule TT1J, the scope of its reconsideration, and whether further evidence should be permitted. So those are the things that will be discussed. Now, the proposed revisions of Rule TT1J, each party has an opportunity to submit its revised rule wording by 4 o'clock tomorrow. So at that point, they have to be in with the EPA, or the Board of Inquiry via the EPA. The board also expressed in its minute that it expects that the parties that submit revised wording will discuss with each other what their proposed rewording is, and in the hope that they can reach some common ground ahead of the conference. So in regard to that particular instruction from the Board of Inquiry, all the parties are setting up a time to confer on Friday, once everyone's had an opportunity to have a look at one another's submissions.
Can I just ask a question? Have we had any, prior to this request from the BOI, have we had any discussions with any other of the other stakeholders prior to this?
What they've put in, what they're proposing to put in, to the best of
Yeah.
my knowledge, no.
None
No.
of them at all.
Don't think so. Yep. Don't think. No, I
So
don't
we
think
haven't
so.
talked to Fish and Game, we haven't talked to Port NZ, we haven't talked to anybody.
If I could correct that, I have before me a public submission from Sainsbury Logan that, if I quote it, says, "We've held a preliminary discussion with the PPI, which is the primary producers group, with a view to agreeing on a proposal that would not require fresh evidence, et cetera, which is one of the key issues of dispute here. So we certainly, a week ago, 21st of January, we're already talking to, I guess, the side of this that we regard as our ally, but we don't seem to have found the time to discuss this with people who have defeated us twice.
Just
First at a board and
order,
then-
councillor. Where did you get that from?
It was a public document, it was filed
Right.
to the Board of Inquiry.
So my understanding is that that was around. All parties were asked to submit comments by the 20th of January, which is a bit that I did miss out, on the process that they suggested to the board should be followed. So it's obviously there has been some discussions with PPI around the process that could be followed. But my understanding of Councillor Bevan's question was around the content of any submission, and so my answer to that is no.
If I may, I could read the whole thing. A key issue that I think we're going to discuss here is the third bullet under the first bullet, whether further evidence should be permitted. There's, I think, a very clear difference of opinion as between our council, PPI, which has a different view, and Fish and Game as to what kind of evidence should be required given the state of play of all of this. And PPI has taken the view that we need plenty more evidence because this rule has far-reaching implications. It's going to set national precedents for how plan changes like this are written, et cetera, et cetera.
Thank you. Well, let's work through.
So we can work our way through the principles that we're looking at proposing, which you will see, Councillor Belford, do not seek fresh evidence to be based on. So any implication that we're colluding with the PPIs around the process and the need for evidence is incorrect.
I'll just respond briefly. I want to come back to Peter Bevan's question. So we've obviously been talking to some people, and Peter's asked, have we been talking to the other parties informally, formally, in a general structure like Fish and Game, etc.? And if not, why not? I would have thought that the central to this is negotiation, discussion. So why haven't we been, knocking on the door, having a talk to them, saying, what do we need to do to fix this? That's what I would have thought would have been the simple first thing to do.
That would be brilliant if they were receptive to that. We are, however, locked in a judicial process that may end up in the Supreme Court, and I'm not sure that much as we love that process to work well, we believe that at this stage we still have a particular position which we are intending to defend, and will work collaboratively during the course of the Board of Inquiry's findings.
That's a very disappointing response, I've got to say, because it just seems to me that we're treating this as a continuing adversarial process.
Order. I mean, let us go through this. We still are in a process.
Yeah.
So let us go through and have some questions at the end. Let's continue.
Excuse me, Chairman.
Could I just sorry.
Can you give us a reference somewhere in this document to Rule TT1J? I want to be reminded as to what it actually says.
I might ask Lara to look that up and explain that. But can I just make a comment, Councillor? We're not the ones that appealed. We're the defendants, And so I think that if there's any, it takes two. And while you may be disappointed in it, it is a formal judicial process.
No, and there's no need to answer. Let's continue with the PowerPoint, and let's generate some more questions. I think that would be a sensible pathway. We're just looking it up, Councillor Dick, and we'll come back to you with that. So let's continue with the PowerPoint. So while Councillor Dick's finding that, can we continue with
We can. So this is what we're proposing for you to consider as the principles by which the redrafting of, a particular condition in a particular rule should be based on. And the first is that the High Court ruled that only Rule TT1J is to be rewritten, and our principle is that we accept that, and our response will meet that criteria with a minimal amount of consequential amendments. I mean, inevitably, when you have a plan provision and you have to change part of it, almost inevitably there are some consequential amendments. It could just be to a reference number or etc. So our view is that we are focusing only on TT1J and any consequential amendments to that. The second principle is that the rewritten Condition J, as we would propose it, should be readily understood, practicable to implement, and be consistent with the National Policy Statement for Freshwater Management 2014, which is as the High Court judge directed in any event. And the third part, which comes back to some reference earlier to comments to the board earlier in January, is that from our point of view, the rewritten Condition J is based on evidence and material already before the board, rather than fresh technical evidence that would necessitate a contested hearing. So do you have any questions on those principles? Any comments, questions?
Councillor Belford. Microphone.
Are there going to be others in addition?
Yes, there are. Yeah.
Well, I would like to go to, I guess, the bottom bullet. The issue, this seems to be an issue of some consternation, whether evidence, further evidence should be permitted or not. I've read the submissions that our council has already made, that PPI has made, that Fish and Game has made. It would appear that we are the only ones saying that fresh evidence should not be brought forward. The other two parties seem to be arguing pretty strenuously that the manner in which this particular rule is implemented and I would presume the strenuousness with which it is implemented is a key issue, and it needs to be supported by evidence one way or the other as to how that should shake out at the end of the day. So I guess, could you further explain why we are taking this position and the other two parties are taking the position they are?
Microphone, please, Helen. Yeah, thank you.
Thank you, Councillor Belford. Just to clarify the starting point of the other parties, the applicants, that's the Regional Council and the Regional Investment Company, lodged a memorandum with the board that suggested that when the board was going through this reconsideration process, it ought to put itself in the position that it was when it first issued its draft decision. And so that process would require, would allow for comments to be made by the parties, but not further evidence. So that is the reason why the applicants have taken that position, because the errors which occurred after the draft decision was released, and it was to do with the process that was followed and also the outcome, so the solution that the board invoked, which was the deeming provision. So as a matter of logic, we're saying the board should go back to where it was when everything was going well and follow that process through to the end, but do it correctly.
So,
If I could just one follow-up to that. If I could just articulate
Microphone.
the PPI view, because I don't think you've responded to the view. You've dealt with your interpretation of a point of law. The PPI is saying, well, first of all, they would like to relitigate the whole thing. They'd like to dump the DIN limit and everything else. Everybody seems to concede that's not in the cards, that's not fair game. I'd like you to confirm that, because I think that's what you say in your memo to them. But leaving that aside, they do say that they go on to make, I think, a not unreasonable argument that this particular rule, and whether, because of its implications for whether, how you regulate nitrogen, intensified farming, et cetera, has huge implications beyond Hawke's Bay, beyond this decision, and we don't want this Board of Inquiry to make a final decision about this without a fuller, robust consideration of whether this type of regulation or the manner in which you would propose to implement it here in Hawke's Bay is really viable. And then secondly, they argue that all of it has such huge economic implications that there should be a Section 2 analysis completed as well that really weighs how all of this would impact the regional economy, blah, 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 blah. And we seem to be sitting here saying, nah, not a problem, based on a arcane interpretation of a legal point here, which we haven't had a great track record of
But aren't
defending.
aren't we still in a process though, Councillor Balfour? So we'll find out how the board deal with
Well,
this
the
tomorrow. If
board-
there's different views, they've got to find a way
The
through
board,
that.
the board, I mean, the chairman of the board specifically asked for a position from all the parties on whether further evidence should be permitted. So I assume that's why we are addressing this issue here today as one of our principles.
And then wouldn't
My
the
view
chairman...
is more evidence is appropriate.
Okay.
So, Chair, I wish to comment on that as well, and it's on the third bullet point up there that I want to comment about, because what I want to see from the balance of the process in front of the Board of Inquiry is a sensible decision for us as the environmental managers responsible for this to be able to carry out our tasks on compliance. Not a fast decision, a sensible decision. And it seems to me that all of the stuff that we've put up so far by way of memorandum is geared towards a fast rather than a sensible decision. And I think that if the Board of Inquiry on reflection feels that they need to hear some more discussion, to get some more evidence in front of them so we get a sensible decision, we need to be flexible enough to accept that that's the best outcome and not be so worried about the speed. I'm really concerned about the type of attitude that we're putting in front of the Board of Inquiry. So I can't support that third bullet point. I think we need to be a bit more flexible in our approach to this.
I think we've been very flexible, but just...
These principles that we are responding to the board on, this is not, the board will make its own decision. If the board says we want more information, we want more evidence, we can't stop them asking for that. We're just saying in this that we understand an enormous amount of evidence has been placed by the board already and they're in a position to be able to. We don't need more evidence. We do not think we need more evidence. But what it does say is the rewritten condition proposed by HBRC should be readily understood, practicable to implement, and consistent with the national policy statement. Those are all the things of writing a good rule. And anyone who's done the making good decisions, you know, knows that all those conditions around being practicable and being what we're after. So it's not a fix-it thing. It is a rule that will work. That's basic principle number one. And I would have thought that covered everything that we need to actually consider.
Okay, let's continue. There's some differing views here. Let's see how the rest, how everything gels together. Continue on, please.
Right. Next principle is that the, again, the rewritten condition J that's prepared by the council should reflect the Board of Inquiry's view that it's not appropriate to require individual farmers or applicants for consents to meet a DIN limit in the receiving waters. When the Board of Inquiry's final decision was issued on the 26th of June, or following its issuing of the decision, the council voted not to appeal any of those aspects to the High Court, or to the High Court. So this is consistent with the Board of Inquiry's final view that it's not appropriate to require individual farmers or applicants to meet a DIN limit in receiving waters.
So can I seek some clarity on that through you, Chair? As I understand it, what the court has said is the factual deeming things in his judgment, or in the Board of Inquiry's final report, doesn't give us the tools to manage the 0.8 DIN limit. Surely that would not give us the tools either, because we have to hold the farmers, whether it's individually or collectively, I'm not quite sure how we do it, but surely we have to have tools to manage the 0.8 DIN limit, and if we can't hang it on individual farmers to do so, how the hell are we going to?
I think that the context of that statement is around that the board felt that the tool for the farmer was the LUC leaching rate. That's what they are obligated to meet, not the in-stream concentration, which could be influenced by a range of other things. So that's what that's saying. It's not about whether the consent process is there as a tool. Okay, it's not about that. And I agree that it is a tool.
But surely the judge said that you're creating factual fiction by allowing that. Surely that's what this is all about.
No, I think you talked about that as the deeming provision, but the board actually said in its reasoning for its decisions that it's not appropriate to require individual consents or individual farmers or applicants to meet the DIN limits in the receiving waters, because there's no way of going back, tracking back doing the sourcing of who contributes what, and given that there are a number of other factors that will influence that as well.
So I go back to my question: if we can't hold individual farmers accountable, how on earth are we going to meet our obligation to get compliance with the 0.8 DIN?
So this probably leads nicely onto the next principle, Councillor, which is really around the importance of, rather than necessarily the DIN limit, of the ecosystem health of the river as the key to managing freshwater quality. And the principle there is that Regional Council recognises that, and that the Tukituki catchment proposal, both Plan Change 6 and the water storage scheme, has always sought an improvement in the ecosystem health of the river. So that's around a whole range of things, not just around